Phoenix, 2 families, the same diagnosis, the same $400,000 house. One signed a revocable trust. The other signed an irrevocable one, 28 months before the diagnosis. When Medicaid came, one family kept the house. The other lost every dollar. Meet Karen and Tom, Phoenix, Arizona. Married 31 years, one house, paid off, and 3 grown children. In March of 2019, they did what careful people do. They saw an attorney and set up a living trust. The deed was retitled. The papers were notarized. They believed the home was finally protected. The attorney was not wrong, exactly. He set up a revocable living trust. It would skip probate and pass the house cleanly to the kids. That part worked perfectly. It just had nothing to do with the threat that was coming. We are the Heir Council. We review the files families leave behind, the autopsies of plans that were supposed to work. The Council's note: this is research, not financial or legal advice. If your family has set up a trust to protect a home, drop your state in the comments. The Council is building a record. Here is the myth almost every family believes, that the word trust means protection. It does not. What protects a home is one structural detail: whether you can still reach what you put inside. A revocable trust is a living document. You can change it. You can dissolve it. You can pull the house back out whenever you want. That flexibility feels safe. It is the exact reason the trust fails. Revocable means you can reach the asset. Medicaid sees that as ownership. If you can reach it, they can count it. And counting it matters more than most families realize. To qualify for long-term care Medicaid, an applicant can usually keep only a couple $1,000s in countable assets. A $400,000 house, counted, blows past that line completely. The family is told to spend it down first. That usually means selling the home. And the proceeds do not pass to the children. They are spent on care, month after month, until almost nothing is left. Then, and only then, does Medicaid begin to pay. An irrevocable trust is the opposite. Once the house goes in, you no longer own it. The trust does, and Medicaid cannot count what you do not own. Giving up ownership sounds frightening, but it does not always mean giving up everything. Depending on the trust, you can still name who inherits. In many cases, you can keep the right to live in the home for life. What you give up is control of the asset itself. That surrender is exactly what puts it out of reach. But there is a clock. Funding an irrevocable trust starts a 60-month look back. 5 years. Move the house too late, and even the right trust protects nothing. So, watch what happened to Karen and Tom. Tom was diagnosed with early Alzheimer's in October 2021. By then, their revocable trust was almost 3 years old. They assumed that made it safe. When Karen applied for Medicaid, the caseworker opened the binder. She read it for a few minutes. Then she made one note: the trust was revocable. Because Karen could still dissolve it, the house still belonged to her, so it still counted. Every dollar of the $400,000, the trust changed nothing. To get Tom covered, Karen sold the house she had lived in for 3 decades. The kitchen, where she raised 3 children. The yard Tom planted. Gone to a buyer in under 90 days. The council's note: this is not a story about a cruel government. Medicaid did exactly what the rule says. This is a story about the wrong word on the right document. And the word matters differently in different states. In most states, a revocable trust is fully countable, the way it was for Karen. Some states lean harder on estate recovery after death instead. But the core pattern holds almost everywhere. Reachable assets get counted. Which state are you in? Drop it in the comments. So, here is what the files show. 3 things separate the families who keep the house from the families who lose it. 1. Revocable means reachable. If you control the assets, Medicaid counts them. The label on the folder does not matter. The control does. This is the single mistake that shows up most. 2. The clock starts when you fund the trust, not when you sign it. An empty, irrevocable trust protects nothing. The assets have to move, and the 5 years run from that day. 3. Avoiding probate is not the same as protecting from Medicaid. A revocable trust does the first, it does almost nothing for the second. Most families are sold the first, and they assume they got both. But here is the question we hear most. What if the trust is already revocable? Is it too late? Not always. An elder law attorney can often restructure it into an irrevocable one. But the clock restarts the day the assets move. So every month of waiting is a month the clock has not started. We have seen families wait for the perfect moment. Then a stroke arrives, or a fall, and the window is gone. The trust that would have worked at 61 months does nothing at 59. And one more thing families ask. Doesn't a will do the same job? No. A will only speaks after death. It does nothing for care costs while you are alive. Now, open the second file. Robert and Linda. Same city, same kind of house, same $400,000. But Robert did one thing differently. He asked a second question. Not just how do we avoid probate, but what happens if one of us needs care? So, in July 2017, Robert signed an irrevocable trust. The house moved into it that summer. 2 years and 4 months before Linda's diagnosis, when Medicaid reviewed their case, the transfer was already seasoned. It sat outside the 5-year window. The house was no longer theirs to count. Robert and Linda lost nothing. When Linda passed, the house went to their children, all 400,000 of it, untouched. Same disease, same house. The difference was 28 months. And one word on the trust. Karen's family or Robert's? Tell us which case is closer to your own. 3 things that careful families do. First, 1. Ask whether the trust is revocable or irrevocable, and ask what that means for Medicaid, not just for probate. 2. Understand the 60-month clock before moving a house or a dollar. The earlier the assets move, the sooner the 5 years are behind you. 3. Talk to an elder law attorney, not only an estate planner. One solves for probate, the other solves for the nursing home. They are not the same job. The file closes here. Yours doesn't have to open the same way. New case every Tuesday. Next week, the council opens another file on a Medicaid rule, one that decides whether a family keeps the house. The council's note: this is not legal advice. Trust rules and the Medicaid look-back vary by state and change often. The families here are illustrative composites of documented pattern failures. Consult an elder law attorney in your state before creating or changing a trust.